And then what I'd like to do is I'm going to start to turn it over to Ashley Westbrook, who we're so happy to have today. And in just a moment, she will be bringing up her PowerPoint and get started on her really wonderful special education um, assistance for behavioral concerns. So Ashley, we see your PowerPoint and you can go ahead.
Great, thanks, Laura. Good afternoon. Today we're going to spend some time learning about the ways that we can use the laws that govern a school district's actions to help students overcome behavioral challenges and succeed in school. This is only one piece of the puzzle to helping a student who is experiencing behavioral challenges, but it's a straightforward step that can often be the beginning of a positive change. My name is Ashley Westbrook. I'm a staff attorney at Legal Assistance of Western New York. My office is located in Geneva, New York, and our organization serves 14 counties in Western New York. Our website is www.lawny.org if you would like more information. And I wanted to note that we're currently accepting new cases from Wayne County. A quick note on a question that I receive often is, when should I call you? If you're looking for general information or have a quick procedural question, Starbridge or any of their partner organizations are a great starting point. However, if you find yourself in a conflict with a school district that you have worked on for a while and it seems to be really stuck, a call to me might be a great step. When in doubt, just call somebody, because we're constantly referring clients to each other, and so there's no wrong choice really. I also want to issue a brief disclaimer that I don't have the rights to any of the photos that you're about to see. So we'll begin by looking at some of the laws that are most commonly used in order to help students with behavioral challenges achieve success in school. I want to say at the outset that this is not a perfect system. If I had a magic wand and I could wave it and completely change the way that schools help students with behavioral challenge, I probably would do that. At the same time, this is the system that we have, and for right now it makes sense to learn about it and to use it to our advantage to help students who are struggling. We will start with the mother load, and I was so excited to see such a high percentage of folks who have IEPs, because it means that you have definitely some familiarity with the Individuals with Disabilities Educational Act. The IDEA is the law that sets up the majority of the special education framework. I'm hopeful that most folks have a good level of familiarity with the law because maybe you've been to a CSE meeting, you've read your student's IEP, all these things are controlled by the IDEA. I will use our first handout to point out a practice tip if you're in the beginning of your IDEA journey with your student. The IDEA sets out a list of 13 categories, and each student who has an IEP has met criteria in one or more of those categories. I think it's very important that if you're going to a CSE meeting for the first time, or going to a CSE meeting where you are concerned that the district will be removing all services from the student, that you sit down with a list of 13 categories. Several of them are going to be easy to cross off as to whether or not they apply to your student. I would encourage you to really spend some time and think through which category you think most appropriately describes your student, and make sure that they are meeting all of the necessary criteria in that chosen category. We'll revisit the most common categories for students with behavioral challenges in a few moments. The IDEA sets out the process that each student must move through in order to receive an IEP, an individualized educational plan. We're going to skip over the early stages of the process to talk about aspects of the process that pertain specifically to students with behavioral challenges. However, it's important to note that there is a lot that needs to happen before we get to figuring out the categories, and Starbridge is always a great resource to walk you through those early phases. For students with behavioral challenges, there are two common categories that we use to provide services through an IEP. The first is called emotional disturbance, or ED. I don't love this term, but no one asked me when they wrote the law. The second most common tends to be other health impairment, or OHI. Let's break down each category together. First, emotional disturbance, or ED classification, requires several things. The student must tick the box on one or more out of a set of 5 criteria. You can see on your screen they're highlighted in lots of different colors, green, aquamarine, purple, orange, and pink. So we need one of those 5. With behavior that's been happening for a while, you can see that in yellow highlighting. They call it a long period of time. That is severe or to a marked degree, also highlighted in yellow. These phrases are, of course, very open to interpretation, which is why lawyers stay employed. How long is a long period of time? How severe is marked? This is why we end up in courtrooms. If you find yourself this deep in the weeds, it may be time to reach out to Starbridge or to me. Just note here that if you feel your student meets one of the 5 criteria, and it's been going on for several months at least, and it's resulted in things like suspensions or expulsions or trips to the hospital, and they don't yet have an IEP, it might be something to take a look at. We'll spend more time with this idea of socially maladjusted, highlighted there at the bottom, in a few minutes. For OHI number 2 on your slide, it's a bit more straightforward. The student needs a diagnosis of ADHD, ADD, or one of the other health problems listed, and this diagnosis needs to be negatively impacting their educational performance. Pretty straightforward. Getting students classified as ED or OHI can often be an uphill battle. Some of the most common pushbacks that we get from schools in trying to move a student with behavioral challenges through the IDEA's framework is that they don't have a learning disability, or their grades are fine, or they don't have a diagnosis, or worst case, they're just a bad kid and they're choosing to act this way. I could spend a full hour just talking about the ways to push back on those ideas, but I will not. Instead, I'll take them each in turn briefly. First, with regard to the assertion that because this is a bright student, they don't need an IEP, please know that grades are not the only measure. If we have a student with behavioral challenges who is pretending to be normal all day during school and then comes home and lights fires and hurts animals, then we have a student who needs special services so that the stress load of the day is not so intense. This student has a disability that is impacting them in their education, despite the fact that they are able to keep their grades up. When I work with districts, we call this looking at the whole child, because courts have been very clear that we are not just evaluating the student that is in the building from 7 or 8 a.m. to 3 p.m. And if behavioral challenges are interfering with the student's ability to be successful and safely inside a classroom, then they are then they are impacting academic performance, whether the grades are suffering in that moment or not. With regard to the they don't have a diagnosis refrain, please know that there is absolutely no law that dictates that a student must be diagnosed with something in order to receive an IEP. For the OHI classification, it certainly goes a long way to have an ADHD or an ADD diagnosis, but with ED, no such diagnosis is required. Does it help when we have medical documentation of the struggles that we're seeing in a student? Absolutely it does. But it's not mandatory for several of the 13 categories. Finally, let's look together at this bad kid concept that I think is woefully common, and specifically called out at the end of the ED classification, which reads, this term, I'm going to go back to it. This term does not apply to children who are socially maladjusted unless it is determined that they have an emotional disturbance. So that last part is sort of circular and redundant, but the first section, I've had schools use this to say kids who are intelligent but who are getting in trouble a lot are just bad kids and not kids who need help. I want to emphasize that I'm a firm believer of the fact that there are no bad kids. There are just kids who are not getting their needs met. School is, for the most part, potentially a really positive place. There are peers there, there is food there, there is hopefully temperature controlled rooms, there are hopefully adults who are looking out for them. There are cool things to learn about. On top of that, it doesn't generally feel good to act out in school. It can be embarrassing, it can make the student feel really out of control. My point is, if a child is struggling in school, it's very rarely because they are just inherently bad or choosing to be bad. It's because they have needs and they found a way that works to meet those needs. If we can help them meet those needs in ways that are less disruptive, more safe, and help along the way to impart skills to that student, then why wouldn't we want to do that? And special education is one way to open the doors to that extra help in meeting needs. Sometimes, as students get older, their IEP needs to be modified in order to include provisions for addressing challenging behaviors. Challenging behaviors might include disruptive behaviors that distract teachers from teaching and students from learning, non-compliance, verbal and physical abuse, property destruction, and aggression towards students or staff. The IDEA requires that if a student with disabilities exhibits problem behaviors that impede his or her learning or the learning of others, then the student's IEP team shall consider strategies, including positive behavioral interventions, strategies, and supports to address that behavior. First, when a student exhibits problem behavior, the IEP team must determine if the behavior impedes his or her learning or other students' learning. Second, if the team decides that the problem behavior does not interfere with the student's learning, or I'm sorry, if the team decides that the problem behavior does interfere with the student's learning, they must conduct an assessment of the behavior. Third, the IEP team must develop a plan based on the information gained from the assessment to reduce problem behaviors and increase socially acceptable behaviors. The results of the team's decisions must be included in the IEP. That's really important. This means that the IEP of a student with serious problem behaviors must include the information from the assessment in the present levels of performance section of the IEP. Because educational needs must be addressed by developing appropriate special education programming, the IEP must also include measurable goals and objectives and special education and related services that address the problematic behavior. Moreover, if that student's behavioral program, what we call a BIP, involves modifications to the general education classroom, these modifications must be included in the IEP. Sometimes we see pushback around this as quote unquote not an IEP issue. That really couldn't be further from the truth. Don't shy away from conversations around behaviors just because they haven't been something that has been spoken about before at the CSE table. Section 504 gets a bad rap sometimes, I think, but I actually like it a lot for working with students with behavioral challenges in particular in comparison with an IEP, what we've just spoken about. The main caution is if you think that your student needs a different school setting, a different classroom, an IEP might be a better bet. Only very rarely have I seen a 504 plan used to change school districts or classrooms. But if you are happy with the classroom that your student is in, and you're primarily looking for environmental changes and changes to how the teachers or staff work with your child, a 504 might be a really great option. So what is a 504 and who gets one? Students can qualify for a 504 plan if they have a physical or mental impairment that affects or limits their ability to do any of the following: walk, breathe, eat, sleep, communicate, see, hear, speak, read, concentrate, think, or learn, stand, bend, lift, or work. And this is not even an exhaustive list. This is all also regardless of the nature or severity of the disability. This is a much broader definition than what the IDEA uses to decide who gets an IEP or doesn't. So more students tend to be able to qualify for 504 plans. We'll save exactly how to get a 504 for a different day, but today I'd like to talk about how to use a 504 to help a student with behavioral challenges. Very briefly, a 504 plan sets out strategies and services used to help students who meet the criteria that we just talked about to get through their day effectively. A student who breaks their leg and temporarily requires crutches and someone to help them carry their things is entitled to a 504 plan. So it really has more to do with all students' rights to receive an education. I'm going to jump around the list that's in front of you a little bit with some different options on how we can use a 504 to help students with behavioral challenges receive what we call FAPE, of free, appropriate public education. One that I really enjoy is use of behavioral management techniques consistently within a classroom and across classes. This one is sort of obvious. Anyone who has kids or works with kids in any capacity understands that behavioral management applied inconsistently is ineffective. But if it's a problem in your student's academic setting, it's a good idea to call it out in the 504 so you can come back to the document if the consistency falls apart at some point during the school year. Utilizing positive verbal and or nonverbal reinforcements. Again, really easy. 504 interventions don't have to be complicated to be effective. We like to see using logical consequences as opposed to punishment. We'll talk more about that in a minute. Confer with the student's parents and the student as appropriate. Establish a homeschool communication system for behavior monitoring. This one is great for younger students who are really poor reporters. I've seen this take the form of a journal, regular emails, monthly meeting, whatever works best for the team is great. Rules and consequences for classroom behavior being posted inside the classroom is often super effective. You can assign a one-to-one aide. Folks are sometimes surprised to find that you can have a one-to-one aide through a 504 plan, but if that's what's necessary to assist a student in effectively addressing the impairment, then that's what's necessary. Planned phone calls is also a favorite of mine. These are awesome for anxiety reduction, and I've seen them be used with some really impressive results. We also can put counseling on a 504 plan, lunch buddies or a special lunch location is a cool one. Using headphones on the bus, special seat on the bus. These are all options that are available. In short, I like 504s because there's a lot of room for creativity. If you have something that you think would help your child, put it out there, see what happens. Now we're going to look at some common problematic responses to difficult behavior and some better options. We'll save our FBA talk for a few minutes from now, but it's at the center of a robust approach to addressing challenging behaviors. It's really important to ask, is this behavior a problem that is covering up an academic problem? So we look at instructional methods and consider remedial services. It's also good to think about, is counseling potentially beneficial? Please be aware that there is a difference between school counseling and private counseling, and that school counselors are required by law to focus on school issues only. It may be useful to do both, but I wouldn't want a parent to think that school counseling is a substitute for good therapy. Aids are available through IEPs and 504s, as we've talked about. As students get older, they may become somewhat averse to this option as it can sort of draw attention. But for younger students, I've seen this work really, really well. We're going to want to work from the bottom to the top on the should nots. We will discuss suspensions more in depth in a few minutes. Holding back is really only for academic issues and for obvious reasons, aka you do not have time for that. The school should not be calling you to share their feelings. I want to note that I took this great list from Advocates for Children, a New York City-based advocacy organization who has a website full of great materials if anyone is interested. Okay, this is a super common one. I wish you were all here sitting in front of me because I would ask, who has ever had their child sent home for a day without that child being suspended? And then you would all raise your hands and I would say, aha! So we are denied that moment in this format, but just know that you are not alone if this is sounding familiar. This is not acceptable. It is not acceptable to send a student home because they are having a bad day. A school has two options: keep the student there or suspend the student. I'm real hard-nosed about this, and I'll tell you why. I know most of the time this is coming from a place of love on the school's part. They don't want the student to get down on themselves. The student really probably does need a breather. All that stuff is true. If this happens once in an academic career, I have no problem with it. The difficulty is that it never happens once. It always turns into a pattern, and then parents lose their jobs, and then they lose houses, and now we're using 3 departments at my law office instead of it just using my department to stop it. So when the school calls to stay, your child needs to take the rest of the day off. This is your script. Are you ready? First you say, is my child suspended? If they say yes, you say, is he a danger to himself or to others? If they say yes again, then you need to go get him. I have prepared a flow chart because nothing in the world sparks joy for me like a flow chart does. As you can see, most of the time your child stays at school. Only if they are suspended and causing an immediate and substantial threat of harm to themselves or others should they be going home before the end of the day. Get ready for pushback on this one, because schools are very used to getting their way on this. But what we want for students who have an overarching behavioral concern is documentation. We don't want the school to be able to diffuse incident after incident by sending the child home at the end we have absolutely no paper trail and no sense of how to fix this. Okay, it's FBA time. FBA stands for Functional Behavioral Assessment, and they are great. They seem to me to be maybe a little underutilized, and they're available for all students, not just students with IEPs. So let's dive in. A functional behavioral assessment is a process of determining why a student engages in behaviors that impede learning and how the student's behavior relates to the environment. An FBA requires a signed parental consent. The FBA includes identification of the behavior, definition of the behavior in concrete terms, identification of the factors that contribute to the behavior, and formulation of a hypothesis of the conditions under which the behavior occurs and consequences that seem to maintain the behavior. An FBA must be based on multiple sources of data. Direct observation of the student is one, information from the student's teachers, and or related service providers, a review of the available data from the student record, and other relevant information provided by the student's parent. The FBA must not be based solely on the student's history of problem behaviors. The FBA must provide a baseline of problem behaviors with regard to frequency, how often they're happening, duration, for how long, intensity and or latency across activities, setting, people, and time of day. It must provide sufficient detail to form the basis for a behavioral intervention plan. So if a school is having one person look at a student in 1 or 2 classes, that's not going to be a sufficient basis to determine what needs to happen in a BIP. It's a little bit hard to see, but here is an example of what an FBA could and should look like. There are lots of examples online if you'd like to see more. A behavioral intervention plan must be based on the results of the FBA, and at a minimum, it includes a description of the problem behavior, global and specific hypotheses as to why the problem behavior occurs, and includes intervention strategies to address the behavior. The CSE considers a BIP for a student exhibiting persistent behaviors after interventions have been tried, whose behavior places himself or herself or others at risk for harm. When a more restrictive program or placement is considered, and or when it is decided at a manifestation determination meeting that the behavior was attributed to the disability. We'll talk more about that in a minute. One thing you should not find in a BIP are punitive consequences like isolation, engaging with the student verbally, corporal punishment, things like this. FBAs and the BIPs that flow from them are designed to give educators the tools to assist with improving behaviors in the school setting. And we know those techniques don't work in getting to that outcome. So as we started to talk about, a BIP must include baseline data of the problem behavior, frequency, duration, intensity, and latency, data across activities, settings, people, and times of the day, baseline data, and a schedule to measure effectiveness of the interventions at scheduled intervals. That one's really important. We want to know how well everything's working. We'll move now to superintendent's hearings, both my lifeblood and also the bane of my existence. They are very complicated, they are very intimidating, mostly you will lose, but let's talk about how you can use them to your advantage when trying to help a student who is having a rough time behaviorally. I did not draw this drawing, but if you asked me to draw a picture of people sitting at a table, it would not be this good. But that's about what this is going to look like. There are several requirements before we even get to the hearing. Notice within 24 hours of the suspension and a telephone call to the parent or person in parental relation to the student. We had started talking about an informal hearing opportunity. It's a great discovery opportunity and a chance to see what the district's case is about, who their witnesses are, things like that. This typically takes the form of a brief meeting with an administrator like a vice principal or a principal. Postponement is also available. And so you can take some time if you feel like you need some time to organize your thoughts or get in touch with witnesses or seek out advocacy, anything like that. Postponement is absolutely allowed of the hearing date itself. Once we get all that stuff done, it's time for the actual hearing. So we'll do legal theory for a moment, which is obviously riveting. It is not riveting, but stick with me. Everyone has a right to an education in this country. Our courts and laws have said that when we take away something that someone has a right to, like freedom or property or education, we must provide something called process before depriving the person of that right. In the case of an education, the process that we must provide prior to taking away that right is called a superintendent's hearing. You are now all legal scholars. Congratulations. The student has some rights at this hearing. The fair hearing requirements include the ability to be represented by an advocate or an attorney, the right to testify in your own defense and call witnesses, the right to cross-examine the witnesses that the school puts up, and the school must present witnesses to the event so they can be crossed, unless safety is an issue. It's important to know that you can waive the hearing and quote-unquote plead. This is a particularly useful bargaining chip when it's obvious that the school can prove the allegations are true. For example, it's on video, 100 people saw it happen, etc. It's common that the school will have no problem proving the allegations, so you want to consider this option with your student in advance. That helps the school avoid costs and save time and may result in a better outcome for your student. A word on off-campus conduct. In order for off-campus conduct to get you in hot water, it needs to have a connection to the school environment. An example would be student A threatening student B online, and then the next day at school, friends of student A reiterating that threat at the direction of student A. An example of no nexus is a thing that happened when I was growing up, which is my neighbor walked 3 miles to the house of a boy who had some negative things to say about his sister and punched him, and then he walked home, told no one, and then resumed friendly relations with the other student the next day. This was in 1995, so I think the chances of it happening anymore are sort of slim with social media and the like, and obviously I am not encouraging this behavior. I'm just using it to demonstrate how something could happen out of school and not impact school. Moving now to the hearing. It's bifurcated, meaning it happens in 2 parts. The first part is called fact-finding. We will call witnesses, we hear testimony, we look at evidence, we find out the facts of the case. The school must present credible testimony that the event occurred. Hearsay is permissible. I will say that again. Hearsay is permissible. It is an administrative hearing and not governed by the evidentiary laws that govern a courtroom. Double secret hearsay or triple or quadruple hearsay is not permissible. I have created another flow chart for our viewing pleasure to illustrate this one as well, although it's looking like the spacing is a little off. But let's see if we can figure it out together. Student A punches student B. and there are no other witnesses. Student B tells the principal about the punch over on the left-hand side. The principal can then testify and be the only person who testifies at the superintendent's hearing. That is fine because although it is hearsay, hearsay is permissible. Let's illustrate what's not okay. Student A punches student B, and there are no witnesses. Student B refuses to talk to anyone about it in the aftermath. It is not okay for a principal to testify about it at this point because that's not even hearsay. It's just guessing. It's a fine line. The general concept is that we need to allow the person who the hearing is about to challenge the school's version of events by having someone who knows what happened talk about it and then be cross-examined about it. When we are done fact-finding, the hearing officer determines if the student did what they are alleged to have done. If they find the allegations were not supported by the facts, that's the end of it. If the hearing officer finds that the school proved that the student did what school said they did, then we move to the penalty phase, where the penalty must be proportionate to what happened. The penalty can be based on the anecdotal record, up to 5 years of behavioral records for the student, but if so, that record must be given in advance. After you go through the superintendent's hearing for a student who has or is suspected of having a disability, there is a second thing that happens. It's called a manifestation determination review, or an MDR. A lot of ink has been spilled figuring out what suspected means, but to my mind, if a parent has in any way alerted the school that they think there is an issue with their child and they are in need of special help, then we have a suspected disability, and we should be conducting an MDR. The districts obviously disagree with me on that, but there we are. An MDR is looking for something called a nexus. A nexus is a fancy way to say a connection between the student's behavior and their known or suspected disability. So your job as you head into the MDR is to talk about all the ways that the behavior got the student in trouble and their disability are connected. MDRs are great. They are, at their foundation, placement meetings to talk about whether or not the classroom is a good fit for this student. But they can feel very rote, and the school will sometimes try to boil them down to something that isn't very helpful. For example, I had a school say to a student who was classified as having a speech language impairment, this wasn't a good classification for him, and we fixed that later. But the school asked him whether or not he understood the words that were said to him. He, as a native speaker of English, did understand the words, "Please put the hood of your hoodie down." So they determined no manifestation. This is why it's really important that we get the classifications right. His response to that command had nothing to do with a speech impairment, and it had to do with years-long trauma history and a total inability to access his frontal lobe during moments of high stress. So we fixed that eventually. I rarely win superintendent's hearings, and I rarely lose MDRs, so they're very important. The other large piece of advice that I would give is to read your student's IEP word for word. If you can demonstrate that the school was substantially not following the IEP at the time of the incident, then the MDR will also find a manifestation and the student will go back to school. A good example of this was when a client of mine whose classroom was required to be bilingual on his IEP was placed in an English-only classroom. He was taunted in Spanish by a peer, and no one was aware of it because no adult in the room spoke Spanish. After several weeks, he finally became upset enough and punched his classmate. He was suspended at the superintendent's hearing, but at the MDR phase, the hearing officer took one look at his IEP and put him back in class. Still the wrong class, unfortunately. And we were then free to work on getting him in the correct placement. We touched on this earlier, but I want to highlight, in any one academic year, where a student is removed from the academic environment for a total of 11 school days, 22 half days, 44 quarter days, what have you, the school must also call an MDR. A removal, the following things qualify as a removal. A command to go sit in the hallway, go to the principal's office, go to an isolation room, anything where the student is told to leave the classroom. I always encourage the families that I work with to maintain a calendar And do your best to track these removals if it's something that seems to be happening frequently. We'll spend a moment on the Basque, which stands for Behavior Assessment System for Children. It's kind of a confusing and very common measure of emotional difficulties that can be administered to students during the CSE eligibility process. So I just want to spend a moment on how it's scored. The Basque rates things that are considered positive and things that are considered negative. In an ideal world, we want really high scores on the positive stuff and low scores on the negative stuff. What we end up seeing with kids who are struggling behaviorally is really low scores on the positive stuff. So the positive stuff is on the right in this picture, and really high scores on the negative stuff on the left in the photo. Sometimes they helpfully highlight the danger zone, like in this photo, but not always. So just take your time when you're reading a Basque. We could do a full day on trauma awareness and ACEs, and I'm sure some of you have already had trainings in this area, so I'll only say a few words about it in this context of challenging school behavior. If you're not familiar with the concept of childhood trauma, Google it and take a look around. In summary, there was a large study conducted several years ago that found that folks who were exposed as children to several of the things listed in this chart had, on average, more negative outcomes than those who had not been exposed to any, or maybe had been exposed to one or two of these. This is not causation. There are plenty of people in the world living full and successful lives who have seen a lot of this stuff. But there is a correlation for our purposes between having a lot of ACEs and having trouble controlling your behavior at school. The reason for that, boiled down for someone who does not like science, which is me, is that ACEs impact our ability to handle stress effectively because they load up our little brain with stress chemicals and hormones at a young age, and we lack the ability to process that stuff effectively when we're little. Then we get a bit older, and the pathways that these hormones and chemicals take are well worn and lead to 15-year-olds having reactions that we would expect from 2-year-olds, but which will get a 15-year-old in much more trouble. In short, kids who don't have a lot of practice using their frontal lobe will not be able to do so when they need to most, and there will be trouble. This is not a death sentence. We can teach these kids the skills that they need to overcome having lived through lots and lots of ACEs. But it takes training for the adults, and it takes patience with these kids as learners, and it's definitely not going to happen overnight. For our purposes today, if you have a student who has a significant trauma history, please make that a part of the conversation in everything that we've talked about today, from the MDR to the 504 meeting. Obviously, we don't want to divulge highly personal experiences of an older child without seeking their permission to do so first. And be mindful about revealing things that could be used against the student in the future, drug use as an example. But to the extent that it's okay with the student, I think that it's important that we think about and talk about this stuff and that it be documented in a student's IEP, 504, BIP, wherever it's appropriate. So that's what I have for today. Thank you so much for listening, and I'd like to take some time for questions if anyone has any.
Great. Thank you so much, Ashley. We do have some questions, and this is your time to also ask your questions. So I'm going to start out with our first question is, where would severe anxiety that affects classroom issues fit within either other health impairment, or would it be more emotional disturbance?
Yeah, so that's a great question. I tend to use emotional disturbance for severe anxiety. I'm going to shimmy back to the criteria quick. What we see in kids with severe anxiety is that they typically are ticking at least one of these boxes. So green, inability to learn that cannot be explained by intellectual, sensory, or other factors, health factors. Inability to build or maintain satisfactory interpersonal relationships with peers and teachers. That's a big one. Inappropriate types of behavior or feelings under normal circumstances. We talk some about acting out versus acting in. ED gets paired more easily with acting out behaviors, throwing desks, yelling, swearing, things like this. But it's also appropriately paired with acting in behaviors. and they can have some of the same results as the acting out behaviors. Um, so when anxiety is leading to behavioral challenges, I tend to look ED. That doesn't mean OHI is closed as an option. Particularly if you have the ADHD diagnosis, that's a great one to look at as well.
Great, thank you.
Yep.
So under a 504 plan, who is responsible to pay for the one-to-one aid for a student?
The district. Isn't that exciting news? So yeah, a 504 plan allows us to make sure that we are providing that FAPE term, free appropriate public education, which every student in the United States of America has a right to. And the free part means that the parent is not financially on the hook for services that a student needs to be able to be successfully in a classroom.
Great, thank you.
Yep.
When do you feel a child should go from a 504 to an IEP?
Oh, that's a really good question. So there's not one answer to that. It's very much case to case. Um, the the main factor is whether or not we need an environmental change, a classroom change, where the school doesn't seem to be working anymore, the particular district, or maybe just that classroom is too big, there's too many students in it. So if you're looking for a smaller class size, maybe a 12-1-1, or, when we work with students with emotional or challenging behaviors, where we tend to see them placed is in 6-1-1s and 8-1-1s. Those are specifically set aside for students with challenging behaviors because those ratios tend to work well in terms of addressing those behaviors on the spot in a really consistent way. So yeah, I would be thinking about the 6-1-1 and the 8-1-1 class for these kinds of students. And in order to get there, you probably are more well served by an IEP. I've seen a 504 used to change a classroom. It's always like weird circumstances, though. It's very rare that that's how it happens. So unfortunately, the answer is every lawyer's favorite answer, which is it depends. But that is actually the answer. I hope that was helpful, though.
Great, thanks. If a child is a runner and escaped school, does
Sure.
the school need to make a plan for that individual child, or can a general school policy cover the response?
Laura, do you want to take this one? The answer is they need to make a specific plan. Um, so yeah, no, absolutely a specific plan. Every kid who elopes is different. Some will elope just into the hallways. Some kids will go out into the parking lot. Some kids will go into the neighbor's yard. And so a catch-all is totally inappropriate for that because it doesn't allow you to deal with the specific dangers that are presented by your student's particular type of elopement. So that's a pretty straightforward one. Feel free to call me if you'd like to. We can talk more about why that is.
Great, thank you. The next one is, should all behavior that is problematic be recorded in your child's permanent school record?
Yeah, so I'd be interested in knowing if they're talking about the anecdotal record, which is a recording of behaviors that rise to the level of like, I'm sorry, I don't have a more artful term for this, but being written up. And so when I hear all problematic behavior, my assumption is that it's problematic behavior, both behaviors that are being written up otherwise and that are not. Um, I had a teacher once, this was so sad, a little boy, and he was probably 8 or so. And the teacher would stand in front of the class and have a notebook on her desk, and every time anybody did anything bad, she wrote it down in that notebook. And so we this up with the administrator during a superintendent's hearing for this student. Um, and the dad made a great point in this case, which is like, where's the good notebook? Where's the notebook where she's writing down the positive things that the kids are doing? Because it didn't exist. It was a rhetorical question. But I think she got some assistance in framing that stuff differently, that like having a negative notebook is not where we want to be.
Great, thank you.
Yep.
The next question is a great question, and we get this a lot.
Okay.
What legal implications exist for before and after school care or daycare settings that are not related to the child's school?
So hit me one more time. So like after-school
So I
program, but the
think the
school's
person,
not hosting it?
yes, and your child is having behaviors, but it's not a school-based program. So if you,
Interesting.
let's say they're having behaviors that may be at a daycare and they're saying, no, thank you, you can't come any longer.
Oh, wow. Yeah. So I'm gonna guess that that depends a little bit on a couple things like, is it uh, an after-school program that's open to the public? Is it for a specific group only? So there's going to be a lot of variability here. But what I can say is that a 504 plan is a plan that can exist outside of the four walls of a school, of a classroom. And so sometimes we talk with seniors about switching over to a 504 plan because they can take it with them to their job, they can take it with them to the military, all sorts of different places. And so I'd be interested to see if the program that you're dealing with would consider implementing a 504 plan to help the student overcome their disability in terms of accessing these services specifically. It may be the case that they are not required to do that, um, depending on what kind of program it is. But I think that's an option. Um, and, appealing, I think, to this general notion of like, this is a child. This is a child that we want to succeed in life. And so giving opportunities like this safely in a way that the child can manage are ultimately really beneficial.
Great, thanks. The next question is, for the intellectual disability classification, do you know what is the IQ that would make a student eligible for the educational classification of ID?
I don't think there's a bright line there. um, you know, Below this number, everybody gets one. Above this number, nobody gets one. I think it's more of a case by case question of, how are we performing academically? What kind of supports and services are we looking for? And how are they going to support the student? So I don't see a bright line. Uh, Anybody, well, no, I hate to even say it because I could see somebody, and IQ is a really arbitrary measure also. So I'm gonna leave it there. There is no bright line.
Great, thank you.
Yep.
The next question is, what would you recommend, and you get these a lot as well, for
Sure.
a child who has behaviors on the school bus? Should an
Oh,
IEP include behavioral supports in transportation?
oh my gosh, yes, 100% it should. Um, so in the transportation section, which is often towards the back of the IEP, is a great chance to write out specifically what the student needs on the bus. And this is going to change like every year as the student changes. Maybe in kindergarten they need a 5-point harness to be able to stay in their seat effectively. Maybe all they need is some headphones and the ability to listen to um, music or watch a movie or something that distracts them during their trip. So it's widely varied. It is, as with all of these, IEP 504, there's a lot of room for creativity. So just think through what's going to be useful and then absolutely add it on the IEP so that everybody's on the same page in knowing that this is what's going to be provided. And you have an ability to kind of check in and say, look, that movie thing was working last year. This year, I think we're going to need to be able to read books instead. I'm just making something up. But yes, included in the IEP.
Great, thank you. This one, and actually you touched on it a little bit. Can a principal who knows the history of
Mhm.
the family or the mother use it against the foster adopted child who suffers from trauma and the triggers that happen in the classroom from the other adults and students? So it sounds like, what happens when a school district knows about the history of a child and it's kind of used against them.
Right, right. Yeah, it's without having more information, that's a tough one to answer because use it against I could see that meaning a lot of different things. What we definitely want is to preserve confidentiality around this stuff. So if you have a student who has a history of being abused, something like sad and horrific like that, um, and the adults in the room know that, we want to make sure that that information is not transferred to the general student population. Um, and yeah, if it's something that you're running into, I would absolutely encourage you to reach out to the school and sit down and have a conversation, either in the formal context of a CSE meeting, or maybe just in a more informal context with the administrator who is maybe not using this information appropriately, and perhaps their boss in order to really drive the point home that it's important that, the things that we know about this student are not shared broadly, because I'm going to go ahead and guess that that would escalate them further.
Thank you. Our next question is, how often does your organization work with either parents or children who have TBI, traumatic brain injury, or MTBI from concussion?
Um, I'm trying to think. I don't know that I've done a TBI case. I would say infrequently. If I have in the 4-ish years that I've been there, it's not immediately coming to mind. But yeah, so infrequently, but not impossible. We certainly wouldn't rule it out. If you met other criteria like uh, the counties that we're covering, our services are income based. And so you have to be below 200% of the federal poverty level, which varies depending on the number of people who are in your household. So I went a little astray there, but as a rule, we certainly would look at a case like that, but it would be dependent on other factors whether or not we would take it.
Great, thank you.
Mhm.
This one I think you get as well a lot. What should a family do if the school says they don't have staff to provide a service that is in the IEP or 504 plan?
Oh my gosh, this is my favorite. Um, the answer to it is very uncaring, and I'm going to sound really unkind because I understand that schools struggle with this stuff and that funding, they're underfunded. Teachers should make way, way more than they do. Um, Understanding all of that, I do not care that they don't have the funding to do it. If it's in the IEP, they have a legal obligation to do that. And that is a winnable due process complaint most of the time. And so it's weird
Thank you.
that it's that simple of an answer, but that's all it is. If it's in the IEP, they must provide it regardless of staffing levels.
So is it something that they could, how do I want to say this,
Yeah.
avoid putting it in the IEP because they don't, let's say, have the funds to hire a one-to-one aide?
Yeah, so in an ideal world, um, absolutely not. That should not be avoided just because of a funding issue. And I had an intern over a summer, maybe 2 or 3 summers ago, look at the funding structure um, for schools. And this guy was an economist in the Obama White House, and he couldn't understand it fully. He was at Yale Law School. And so, needless to say, this is a really complicated funding structure. Um, but I think that by and large, when they provide services, schools do get reimbursed. Not right away. I know that's problematic. And it depends, like federally or state, but absolutely, in an ideal world, they should be giving the students what they need based on, who they are as people and not based on how much money the school has. I understand that where the rubber hits the road. Does that happen all the time? Constantly. We are constantly seeing kids who are misplaced or misserviced because the resources aren't there. So I understand it happens, but it shouldn't happen in an ideal world.
Great, thank you. This one, and I hope I'm capturing it correctly, it sounds like it was also from the student who had trauma in their past, but what do you do if the school is constantly um, it says call the cops and send them home for mental health checks, and or maybe reporting the parents. So, do you have any suggestions when parents get reported, maybe to CPS, or they're calling because they think something is going on in the home? Do you have any guidance for families who maybe there's this conflict between them and the school that's going on?
Yeah, that's really tough. Um, so I would reach out for some advocacy assistance at that point, probably to Starbridge, maybe to my office. Um, I'll say a word about CPS stuff. It's really, really emotional to have CPS show up at your door and accuse you of not taking care of your child. This thing that is like incredibly deeply important to all parents, to be told that you're not doing it properly just sets off alarm bells for everybody I know. And so I am sympathetic to the emotion that that creates for folks. With my lawyer hat on, I would say, be cooperative with CPS, realize that they're not your best friend. So be a little cautious, but I think professionalism and courtesy go a really long way in terms of dealing with CPS. And that at the end of the day, if nothing is wrong, CPS is not going to found a report, meaning that they're not going to say, there is a terrible thing going on and we have to submit a report of abuse or neglect or whatever, and we have to go to family court. If there's nothing, then nothing should happen. And so it's hard to feel that um, when you're in the middle of your door getting knocked on during dinner time. But to the extent that you can, try not to worry about it too much if there's nothing to worry about. Um, and, if they find something that you think was incorrect or they get their stories turned around, all of this stuff is appealable. And every CPS notice on the back of it is the way to appeal the determination or the finding of neglect. Um, don't shy away from that process. It's not used very frequently, but it's pretty user friendly. It's pretty straightforward. And if you feel like the finding of neglect or abuse was incorrect, feel free to use it. Um, so that was one half of that, and the other was for the student with the mental health arrest. Is that right, Laura?
Yes.
Yeah, so these are tough also. We're seeing schools do this a little bit more frequently, call the police, and then ultimately what the police know how to do is to take that student who is in crisis to the hospital. And that's a fine intervention a lot of the time. Um, it can, I've seen cases where that is like everybody's first reaction to a student who's been brought to the hospital frequently. And so you can get in ruts where, okay, my daughter is flipping out, and so we're going to call the police. The police are going to bring her to the hospital, and then she's going to stay there for 2 days, and then nothing's going to happen. And that happens 10 times over the course of, a couple weeks. And so what you want to do at that point is absolutely call a CSE if they have an IEP, or just call a team meeting even if they don't, and say, look, this is the cycle that we're seeing. It's not working. What can we do differently? An FBA, a functional behavioral assessment process, is available to all students, even students without IEPs or 504 plans. And so, ask for an FBA if it's not something that you've already done. Have them take a look at the behavior, what's triggering it. Different people have different reactions to a student running around and cursing in the hallways. Like for some people, that's whatever. For me, that's whatever. But some people see that and they're like, this is a crisis. And so you have to kind of calibrate for people's different reaction to it. But always, always, I would just stay in good communication with the school. Communication is your friend. And if they're not calling you, then calling you back after you call, then call somebody else. You got to keep trying.
Great, thank you. We do have one last question,
Okay,
and before we get to that, I just want to remind everyone that if you click on over on your right-hand side, handouts, you want to download the 13 classifications as well as a copy of this PowerPoint so that you have this. And I also want to remind you that you will get a link to a SurveyMonkey. Please take a moment and fill out the workshop feedback. This allows us to have our funders provide these types of webinars free of charge. This will be archived. It usually takes about 6 weeks for that to happen. With that being said, the last question is, and again, great question, if a student is suspended from transportation, does a parent need to transport the student? Or who would be responsible for transporting the student?
that is a great question, and I feel like I knew this answer at some point, and it's escaping me right now. I want to say that the school is on the hook to do it, just in a way that is safe. But they can,
Mhm, mhm.
if that's not feasible, then it may shift to the parent. Does that jive with your understanding, Laura?
It does, and I think that you and I have worked on some cases years ago where it kind of comes to the conclusion the parent's working and there's really no way for the student. I think we worked on one where the student couldn't, no one was able to take the student,
Yeah. Yep.
and so they had to come up with a method to get the student, or else they weren't going to have access to education.
Right, right. Yep, so burden falls on the district for the most part.
Great, thank you. Thank you so much. There's great comments in here about thank you so much. This has been so
Oh,
helpful.
I'm so glad. Thank you.
Um, very complex issues. Again, if Ashley is taking cases, if you live in Wayne County, but if you feel that it's something of a legal aspect, you definitely, we would want you to get in touch with her. If she feels that it's not ready to be a legal issue, she will then refer you on to us here at Starbridge. There is her contact information. She is a wealth of knowledge. I know we use her all the time, and a lot of times we work together. So, Ashley,
Absolutely.
thank you so much. We're so pleased that you were able to join us today.
Oh my gosh, totally my pleasure. It's been a great time.
Great. Thank you, everyone, for joining us. And tomorrow, we're actually doing a webinar on executive function. I think we only have like 2 or 3 more spots left if you haven't signed up for that. And we are actually planning a future webinar with Ashley on bullying in October. So you definitely want to stay tuned for that. So thank you so much, and everyone have a great day.